Hello and welcome to another episode of The Letter of the Law through Bloomsbury Institute London. This episode will also feature on the London Legal Podcast as organised and promoted by Hodge Jones Allen Solicitors. Today the subject turns to the area of dispute resolution, particularly property disputes, and we're talking about the Renters' Right Act, of which Phase 1 will be implemented from the 1st of May of this year. And it's been described as a landmark legislation, marking one of the most significant reforms to England's private rented sector in nearly 40 years. To join us to talk about this important subject are two partners from Hodge Jones Allen Solicitors. We have Ruhul Ameen and Bahareh Amani, both partners at Hodge Jones Solicitors in their dispute resolution team. Let's turn to Ruhul first. How are you doing today?
I'm very well, thank you.
And Bahareh, how are you?
Hi, Sarav. Nice to see you again. Good.
Great. So the way we start out the show, as usual, is we learn a bit more about our guests. So, Ruhul, let me turn to you. If an audience member is tuning in right now and they want to know a bit more about you, could you talk to us about your experience, how long you've been with HJA, for example?
Well, I'm a partner and solicitor in the dispute resolution team at Hodge Jones Allen. I have over 20 years' experience in dealing with litigation cases. I qualified as a solicitor in 1999 and became a partner at Hodge Jones Allen in 2020. I specialise in property disputes, including landlord and tenant matters, but I also deal with other civil and commercial disputes, in particular professional negligence and contested probate matters. I regularly represent clients across all levels of the courts and tribunals, and I try and combine my strong litigation skills with negotiation mediation to promote the best interests of my clients.
And Bahareh, can we understand a bit more about yourself and your experience, please?
I'm also a partner in the dispute resolution and property dispute team at Hodge Jones Allen. I qualified as a solicitor in February 2010 and joined Hodge Jones Allen in 2018. I initially joined in the housing team as a senior associate, but was promoted to partner in May 2020, having specialised in litigation and property disputes since I qualified in 2010. I also handle a wide range of property and dispute resolution matters, including disrepair claims, landlord and tenant disputes, freehold and leasehold disputes, possession proceedings, and I've also in the past undertaken appeals against local authorities. In addition to working on freeholder and leaseholder disputes, I also undertake wider commercial and civil disputes, along with working on contested probate and contractual cases. I'm experienced in advocacy and negotiating settlements and representing clients at all court levels. Before joining Hodge Jones Allen, I spent over 8 years at another firm where I became partner as well as housing supervisor. I enjoyed defending possession claims and pursuing disrepair matters on behalf of my clients, often achieving negotiated outcomes without the need for trial. I've been recognised as a next generation partner by the Legal 500.
Thank you very much, both. And Hodge Jones Allen Solicitors is just down the road from where we're recording today at Bloomsbury Institute, London. Now, Hodge Jones Allen Solicitors has quite a history, doesn't it, Ruhul? Could you tell us a bit more about the firm, please?
Yes, of course. The firm was set up in 1977, almost 50 years ago now, by Henry Hodge, Peter Jones and Patrick Allen. They were committed to helping individuals who would otherwise not be able to gain access to justice. Since then, the firm has grown over the years, and we now have over 250 members of staff, and most recently featured in the Best Times Law Firms 2026 list, which ranks the top 250 law firms in England and Wales. Hodge Jones Allen Solicitors has a number of teams that assist people with their legal issues, ranging from asbestos diseases, other personal injury or medical negligence claim, criminal defence work, wills and probate, and many other areas of the law that people from all walks of life may need help with. Each area of law that we cover has specialist teams, so our clients know they are in experienced hands. Everyone who works at Hodge Jones Allen follows the philosophy of helping people gain access to the law, irrelevant of a client's means or background. And this ethos has always been at the forefront of what we do. I'm very proud to be part of Hodge Jones Allen.
Thank you very much. Now, if you're tuning in, we are speaking with two partners from Hodge Jones Allen Solicitors, specifically from their dispute resolution team. We're speaking with Ruhul Ameen and Bahareh Amani. The subject today is the area of property disputes, specifically the Renters' Rights Act. Now, phase 1 of that act will be implemented from the 1st of May 2026, and it's been described as a landmark piece of legislation, and it marks one of the most significant reforms to England's private rented sector in nearly 40 years. Now, before we get into this specific topic, just like to raise the point that if you want to know more about Hodge Jones Allen Solicitors, please visit www.hjA.net. And if you'd like to learn more about the area of the Renters' Rights Act, potentially to make an inquiry or to find out more information or to learn more about your legal rights, then get in touch with Hodge Jones Allen via the phone on 033 00 294 446 or via email at billradio@hja.net. That's BIL radio, all one word, at hja.net. Now, Bahareh, let's turn to you, the Renters' Rights Act. Now, what exactly, in general terms, does this act mean for landlords and tenants?
So, as you've said, Swarav, the Renters' Rights Act 2025 represents a significant change to renting in England. The legislation, which received Royal Assent in October 2025, is expected to take effect in phase from the 1st of May. Now, in general terms, the Renters' Rights Bill represents a major rebalancing of the relationship between landlords and tenants in the private sector in England. Its core effect is to increase security and protection for tenants, whilst also raising responsibilities, regulation and risk management requirements for landlords. What does that mean? The reform is going to include the abolition of no-fault evictions, what many people know as the Section 21. It means landlords will only be able to evict their tenants for specific, legally defined reasons, such as antisocial behaviour or an intention to sell the property or rent arrears in specific circumstances.
Okay, and Ruhul, the aim and scope of the Act, what's behind how the Act came to fruition and its general aims?
Well, the Renters' Rights Act aims to make the private rented sector in England fairer, safer and more secure for tenants, whilst at the same time supporting reasonable landlords. Its key aims are to end unfair evictions by abolishing no-fault known as Section 21 evictions, improve stability and fairness by giving tenants greater security and clearer, transparent renting rules, raise housing standards by requiring all private rented homes to meet minimum quality and safety standards, prevent discrimination and unfair practices by including bans on tenants with children or on benefits, and also stop rental bidding wars. It also strengthens enforcement rules by giving councils and tribunals stronger powers. Overall, the Act seeks to rebalance the relationship between landlords and tenants and reduce the insecurity linked to poor health, financial stress and weaker communities.
Thank you. So if you're listening today to this conversation and you're a landlord or a tenant, or you know someone who might be, or someone even in your family to whom these issues pertain to and maybe it affects what they're dealing with at this current time, then you can make an inquiry or you can learn more about your legal rights, and you can do so by getting in touch with Hodge Jones Allen Solicitors via phone on 033 00 294 446 or via email at bilradio@hja.net. Now, if you're just tuning in on the Letter of the Law, we are speaking with two partners from Hodge Jones Allen Solicitors, Ruhul Ameen and Bahareh Amani from the Dispute Resolution Team. And we're speaking about the Renters' Rights Act, which phase 1 of which will be implemented from the 1st of May of this year. It's a landmark piece of legislation and it marks one of the most significant reforms to the private rented sector in this country for nearly 40 years. Now, as I mentioned, there are two sort of distinct groups that are affected: tenants and landlords. Let's turn to tenants first of all. And Ruhul, could you talk about how tenants will be impacted by this act?
The reforms will offer more security to tenants. Tenancies become open-ended, so tenants can stay longer but leave with 2 months' notice. No-fault evictions will be removed, meaning landlords must have a valid reason to end a tenancy. It will provide stronger eviction protections as evictions are only allowed for clear reasons, such as serious rent arrears or antisocial behaviour, and usually require longer notice. Bring fairer rent rules, as rent can only be increased once a year with proper notice, and tenants can challenge unfair increases. Rental bidding wars are to be banned. It will reduce discrimination, as landlords cannot now refuse tenants just because they have children or receive benefits. It will provide better living accommodations, as living standards on all private rented homes must meet a decent home standard, including fixing issues like damp or mould. There are also extra rights, so that tenant can now ask to keep pets, which cannot be unreasonably refused by landlord, and have better access to dispute resolution should any problem arise.
Thank you, Ruhul. So you've talked about how the Renters' Rights Act can potentially impact tenants. Now we switch to the other side. We're talking about landlords. And Bahareh, let's turn to you. What are some of the key measures of this act that will impact landlords?
Right, so there's a few steps that landlords can take in order to ensure that their impact is limited. So the first thing that you should be doing is reviewing your portfolio and your risk. What does that mean? Identify properties that may struggle to meet that decent home standard. That tends to be in the older homes, those that are likely to be damp and have poor insulation. Check your tenants' profiles and their rents. Do you think that your tenant is financially stretched? Are rents near the market level? How much more can you maximise on that? And assess your own cash flow and mortgage terms in case the rent increases are limited or evictions take longer. And what does that mean? If you're likely to have a higher interest rate on your mortgage, or if you're going to be in a tighter financial position but are hoping on an increased market rent, that may not be possible. So assess your own cash flow and mortgage terms. That will then help you decide whether you need to invest, hold, or exit. Now, in terms of the open-end tenancies, be prepared that you can't just ask your tenant to leave. The updated tenancy agreements for your tenancy agreement will essentially mean that your tenancies become periodic. They are open-ended, and so the new rent review rules will follow. This isn't just for tenancies going forward, this would be for all tenancies. Focus on your tenant retention rather than a short-term churn. That will ensure longevity, longer standing relationships that you would have with your tenants, and plan for longer possession timelines. And what does that mean that you need to do? That means you need to ensure that you have an increased cash buffer and a stress test finance. Possession proceedings are already taking a considerable longer period of time post-COVID, and it's likely that that timeline will further increase. Making sure that you have a good tenant selection and communication with your tenant is crucial. Invest in property standards and compliance early. Don't wait until a problem arises, or don't wait until the tenant raises issues and difficulties. Audit your properties as regular as possible. Check the damp, the mould, heating, insulation, electrics, gas safety regularly and periodically. But also budgeting for upgrades that you may need to cost incur, such as those that would need to ensure that the property meets the decent home standard. And whilst undertaking all of those steps, ensure that you keep clear repair records and logs, whether that is through complaints or matters that have been raised by your tenant, or those through your own periodical inspections. Early compliance is always cheaper and far more economical than undertaking urgent repair work later. What else do you need to do? You need to strengthen your documentation and your records. Ensure that you keep an accurate record of your rent changes, the notices, the repairs and safety certificates, and above all, the communication with your tenant. Document reasons if you are refusing pets, or if you are taking possession action. If, for example, you're in a leasehold property and you're not allowed to permit animals or pets in a property, ensure that's communicated and you have the evidence to back it up. Understanding the process of court proceedings and tribunal evidence standards will be key in order to safeguard your position. If you can't prove it, you cannot assume that it just didn't happen. You have to ensure that you have sufficient evidence and documentation to safeguard your own position.
Are you a landlord that's listening to this conversation, and if some of what Bahareh Amani has been speaking about is of relevance to you or someone you know, then please do get in touch. You might want to learn more about your legal rights, to understand a bit more detail about what Bahareh has just been speaking about. And you can do so with a phone call on 03300 294 446, or get in touch via email at bilradio, all one word, at hja.net. If you're tuning in, we're speaking about the Renters' Rights Act as it pertains to landlords and tenants. It's a significant piece of legislation, and it's going to be implemented from the 1st of May of this year. It's been described as a landmark piece of legislation, and it marks one of the most significant reforms to England's private rented sector in nearly 40 years. We were just hearing from partner Bahareh Amani from Hodge Jones Allen solicitors. She was detailing some of the impacts on landlords, and now partner Ruhul Ameen is going to talk about some more of the impacts on landlords. Ruhul, could you go into some of the other significant impacts on landlords, please?
Yes, of course. Landlords will, in my view, need to adjust their financial planning and rent strategy going forward by setting rents at realistic market levels. They'll need to plan for a 1-year rent increase, have longer voids and slow arrears recovery. They will need to maintain contingency funds for expenses such as legal costs, repair and compliance costs. Cash flow will now matter more than chasing yield. They will also need to prepare for registration, the Ombudsman scheme and enforcement changes. They will need to register on the new private rented sector database, join the mandatory Ombudsman scheme, and know about the local authority enforcement powers and penalties. Compliance now needs to be proactive rather than reactive. They also will need to become more professional and treat the letting as a regulated business, not a side investment. Use professional agents and or legal advisors, and operate at a scale that can absorb risk. Some landlords may consolidate, partner with build to rent, or exit high-risk properties. They will need to communicate more with their tenants by explaining the changes clearly and reassure tenants about security and standards. They can use this as an opportunity to reset relationships, so trust and transparency will reduce disputes and turnover. In conclusion, landlords who act early by upgrading standards, shoring up their finances and being professional will remain competitive. Those relying on short-term flexibility or minimal compliance will struggle under the new regime.
Thank you. So if you're tuning in, we're on the Letter of the Law through Bloomsbury Institute, London, and we're speaking with two lawyers from Hodge Jones Allen solicitors, partners within the dispute resolution team. That's Ruhul Ameen and Bahareh Amani. We're talking about the Renters' Rights Act. So whether you're a tenant or you're a landlord, this is a really important piece of legislation. It's phase one of this piece of legislation is going to be implemented from the 1st of May of this year, and it's a landmark piece of legislation marking one of the most significant reforms to the private rented sector in nearly 40 years in this country. Now, whether you're a tenant or you're a landlord, or if you've just joined and you know someone who might be, and you're conscious about how this act is going to impact your portfolio or your renting situation, then please do get in touch to learn more about your legal rights, or perhaps to even make an inquiry. And you can do that with the partners at Hodge Jones Allen Solicitors and their team via phone on 03300 294 446, or via email at billradio@hja.net. And of course, to learn more about Hodge Jones Allen Solicitors and their dispute resolution team, you can visit them on www.hja.net. Now, the Renters' Rights Act has been subject to a great deal of discussion through media on different forums, and some of those issues and the market impact that that act involves are going to be the point of discussion between Bahareh and Ruhul right now. So I'm going to throw it open to both of you now, Ruhul and Bahareh. This act will involve a lot of different market impacts, and also there may be a number of future trends associated with this piece of legislation once it's underway from May. Could you both talk about some of the different future trends and likely market impacts of this act? Bahareh, let's start with you.
Okay, Ruhul, first question. Do you think the tenant turnover will go up or down?
Well, that's an interesting question, Bahareh. I mean, on one side, turnover could increase. Tenants can now leave with just 2 months' notice, no fixed term tying them in. So people might move more often for better rent, a new job, or just a lifestyle change, especially in busy areas. Landlords could, as a result, end up with higher voids, extra admin, and more letting costs.
True, but there's also the other side. With Section 21 gone, tenants no longer have that worry about sudden eviction. So that security might make people want to stay longer, put down roots, especially for those with families or older renters who really value stability.
Yes, so we probably could see a split with renters moving around more, but long-term tenants and families staying put.
Yeah, no, I agree. Okay, next. Ruhul, do you think landlords face higher costs and admin?
Probably at first, Bahareh. There is more compliance to worry about. Decent home standards, ombudsman membership, landlord database registration, plus longer eviction processes and rent arrears being capped at once a year. That adds financial and admin pressure on landlords.
That said, maybe those initial costs are all front-loaded, and hopefully after time costs might begin to level out. The clearer rules could actually reduce disputes, better relationships between landlords and tenants, and the better home standard might simply mean fewer surprise repairs, and those professional landlords could come out ahead. And it's really about scale and how organised you are and being ready and prepared to embark upon this new legislative change. So we've got the higher costs and admin, we've got the tenant turnover. What about communities? Do you think the Act is going to make communities more stable or less so?
Definitely in some cases. Longer tenancies let people put down roots, engage with schools and get involved with neighbours. Less forced moving is good for kids and mental well-being.
Absolutely, but there is a catch to that. If the rental supply drops and goes down, tenants could then face more competition and fewer choices. And then some landlords may then decide to switch to short-term lets, which really doesn't help with the issue of stability. So I think it really depends on the local market and what is available out there.
Right. Now, Bahareh, what about landlords leaving the market? Do you think we'll see a big exodus?
Potentially, those smaller or highly leveraged landlords might decide it's just too risky and it's not worth the hassle, the effort, the demands and the risks, and that could then subsequently reduce supply. As a result, rents might then go up.
But I don't think it'll all be that catastrophic. Many of those properties get picked up by other landlords or build-to-rent operators. Big institutional landlords might actually expand because longer term tenants and clearer rules make things more predictable. So we might see a shift in landlord profile, not necessarily a collapse of supply.
Yes, well, one certainly hopes so. Looking further ahead, Ruhul, what trends do you see?
Well, I think we'll see fewer hobby landlords, but more corporate landlords and tighter tenant selection. Even with the discrimination bans, landlords are likely to be cautious. Rents could rise in high demand areas if supply dips, and build to rent schemes are likely to grow. Plus, everyone, landlords and tenants, will need to really understand the rules.
Absolutely. Ultimately, the key here is literacy. If you are going to be legally literate, you will be a successful player in this change. So the key, being legally literate, is going to help you.
So to sum up, the Act will improve security and standards for tenants, but it brings extra risk, less flexibility and more compliance for landlords.
Exactly. And the real market impact will come down to how landlords respond. Whether professional landlords and build-to-rent schemes can make up for any small landlord exit, or whether the market will struggle with the impact that it will have on that small-scale landlord.
Yes, I agree.
Thank you. So we've been speaking about the Renters' Rights Act so far, and we've been speaking with Ruhul Ameen and Bahareh Amani, both partners at Hodge Jones Allen Solicitors from their dispute resolution team. Now, if you're listening to this conversation and you feel that you would like to take the matters of your particular case forward, perhaps you think there's an inquiry there, or you just want to learn more about your legal rights, then of course you can get in touch with Hodge Jones Allen Solicitors. You can speak to Ruhul or Bahareh, and you can do that via phone on 033 00 294 446 or via email at billradio, BILRADIO at HJA.net. If you just want to find out a bit more about both Ruhul and or Bahareh and about the team within which they work, then go ahead and visit them online on www.hja.net. So Bahareh, if someone's listening to this conversation, whether a landlord or a tenant, they're potentially thinking about making an inquiry, but they're conscious about how they pay for their case, what would you say to them?
So at Hodge Jones Allen, we offer an array of funding options to include private paying, conditional fee agreements, which are known as no-win, no fees, liaising with your insurance provider if you have legal expenses insurance cover, and legal aid in certain matters that are in scope and subject to your financial eligibility and entitlement. If you are a landlord, you will most likely have to pay for our services under a private fee paying retainer or through an insurance provider policy that you may have for legal expenses insurance. For further details, do not hesitate to contact our offices, who would be more than happy to discuss your matter with you.
Thank you. And if you do wish to contact the offices of Hodge Jones Allen, you can do that via phone on 033 00 294 446 or via email at billradio, BILRadio at HJA.net. That brings us to the close of our conversation. We've been speaking with partners Ruhul Ameen and Bahareh Amani, both from the dispute resolution team of Hodge Jones Allen Solicitors. Ruhul, if someone's listening to this and they want to learn a bit more about you, how can they get hold of you?
Yes, of course. If you would like to learn more about the specific work I do, the cases I've dealt with and the work my team undertakes to help those looking to resolve a dispute, please visit our website at www.hja.net and look up my profile.
And Bahareh, what if a listener wants to get hold of you?
If you'd like to learn more about the specific work that I do, the cases I've dealt with, and the work my team undertakes to help clients looking to resolve a dispute, please visit www.hja.net and look up my profile under Bahareh Amani.
So yes, if you'd like to make an inquiry, learn more about your legal rights in the area of the Renters' Rights Act, whether you're a landlord or a tenant, do get in touch with Hodge Jones Allen Solicitors via phone. The number again is 033 00 294 446 or via email at bilradio@ha.net. It's goodbye for now, but we look forward to speaking with you on the next episode of The Letter of the Law. Thanks for listening.